And I'm joined now by Sherilyn Ifill, who leads the 14th Amendment Center for Law and Democracy at Howard University, and George Mason University Law School professor Jennifer Mascott, a former clerk for both Clarence Thomas and Brett Kavanaugh. Thank you both for being here. Sherilyn, big picture, looking at this term, this was really a defining moment in some sense, for the Trump court, 3 Trump justices.
Yes, it was. I mean, I think this is what we expected from these justices. We all knew that these cases were coming through the pipeline. And what this court has shown since these justices joined the court is a really aggressive approach to dismantling core and critical issues that have been championed on the progressive left and that are really part of the infrastructure of our country, our kind of post-civil rights country. They're moving quickly. I think they're moving in some ways in a manner that actually undercuts their legitimacy. And they are taking steps at a time when our country is deeply divided that I think will result in further division. I think this affirmative action decision is disastrous, is a mistake, and we're going to be left with the consequences of it.
I want to get to that specifically in a moment. But Jen, first, more than anything, this was a Roberts court. I mean, we had 59 decisions. He was in the majority 55 times. And there were some surprising wins for the liberals on the court.
Well, I think that's true. And I actually think this term, there's more consensus than there maybe has been the last several terms and less polarization. And if you look at some statistics put together by some Supreme Court advocates, at least current through the next to last day of the term this year, it was Justice Thomas and Justice Alito who more frequently were in dissent. I think Justice Kagan last term had perhaps over 20 dissents, this term 10 or fewer. And so that suggests that actually the court's not necessarily always aligning how we would expect, but they're trying to decide each individual case in accordance with the rule of law as they understand it.
So on the affirmative action case, you heard in Devin's story there's an effort from Harvard and from other schools to say, we are continuing our commitment to diversity. We're just going to have to do it in a different way.
Well, that's easier said than done. And if you look at schools in California, which outlawed affirmative action in 1996, you will see that it is quite challenging. And, it's important to remember the whole point of affirmative action, which is to create this environment where people from all different backgrounds can engage, can do problem solving, can innovate, can learn about each other, and particularly at selective institutions, which, whether you like it or not, tend to be the places from which the nation's leaders emanate. And so if
8 out of 9 of the justices went to Harvard or Yale.
I'm just saying, if these are the places that are incubating the leadership of this country, I would think at this moment in our country, we would recognize that universities are quite correct, that incubation has to happen in a way that trains leaders who are equipped and prepared to deal with people of different backgrounds, who have been exposed to different perspectives, who have knowledge of lifestyles and ways of thinking that are different than their own. I certainly experienced this when I went to college. I, too, am from Queens, like the young men that were in that segment, youngest of 10 children. And when I went to Vassar College, I learned about a whole different way of life and different worlds. And I like to think that my friends, many of whom were white and with whom I was quite close, learned a lot about the life that I led and about different perspectives, and that it shaped their lives. So that was the whole point of this, and to have this dismantled, it seems to me, is going to be quite difficult, and I think it's quite dangerous, actually, for our democracy at this moment.
In what had been the landmark decision, the Bakke decision in 1978, Justice Powell, who was the deciding factor in that decision, said that universities, colleges have a compelling interest in having a diverse student body. Is the court now saying, Jen, that there is no longer such a compelling interest?
Well, the Chief Justice's opinion that 6 justices joined said, in consistency with the strict scrutiny standard, that there has to be a compelling interest that's narrowly tailored. And the Chief, in his opinion, said that the way in which the interest has been explained here by Harvard and UNC was tough to measure, and that there was not anywhere close in those situations of enough of a nexus. I think the justices also were concerned about, in general, broad-based stereotypes, and that Asian Americans in particular had been negatively facing stereotypes under some of the admissions criteria. And so 6 justices joined the reasoning saying that there can't be discrimination or separate treatment on the basis of race. It maybe can be looked at as an individual factor if an applicant ties it to other circumstances in their life, but no longer will people be favored on the basis of class and race and admissions.
Well, see, that's difficult because, in fact, this is a holistic admissions process that actually doesn't just look at race isolated and independently, but within the context of many other factors. And I think what I find most disturbing about the majority's decision in this case is that in both of these cases, there were trials. There was extensive evidence that was submitted. There were expert witnesses. There were graphs. There were charts. There were students who testified in favor of affirmative action. And after a two-week trial in the Harvard case, we get a decision from a federal court judge, 130 pages. In the UNC case, 155 pages, meticulously going through the information that was submitted, that was vetted, that was subject to cross-examination, and concluded quite the opposite, that, in fact, these admissions processes do not discriminate against Asian Americans. That's the way our legal system works, is that we actually subject things to the rigor of trial. We get a fact-finding decision from the district court, as we did in both of these cases. The fact that 6 justices have a different opinion or a hunch about what they think is going on is not actually the way the legal system is supposed to work.
All right, Sherilyn Ifill, Jenn Mascott, thank you both.